efficient and informative. So we are very grateful to have you here for this Human Rights Conference. My name is Cecil. I'm an assistant professor of law at the great Gonzaga University School of Law in Spokane, Washington. Very delighted to be here with you all today to discuss a very important topic with excellent panelists to my left and right. The topic of our panel is executive aggrandizement and human rights from comparative perspective. Right, so we have both Professors Vaibhabi Rane and Professor Nguen, right, who are going to offer presentations on very important topics that at the interplay of land use policy, climate justice, and executive power. Right, so a very relevant topic in a globalized world. So let's begin with some brief introductions, and then we'll kick it off to Professor Rane. Professor Nguen is a senior lecturer at the Faculty of International Law, Diplomatic Academy of Vietnam, and just arrived here yesterday and is leaving tomorrow, so we will welcome her for her brief time here. She earned her master's degree in international law with first-class honors from the University of Auckland, New Zealand. Her research focuses on public international law, international human rights law, and international humanitarian law. Nguen is also the president of DAV's Moot Court Community and member of the Supervisors Board of Vietnam's Society of International Law. To my right is Professor Vaibhabi Rane. Professor Rane is an assistant professor at the Manohar Parrikar School of Law, Governance and Public Policy, Goa University, where she also serves as the program director for the LLM program. Professor Rane's work lies at the intersection of international human rights law, international economic law, and environmental governance, with a focus on migration, climate change, and sovereign financing. She is currently the principal investigator of a funded research project titled, quote, Adapting Coastal Regulations to Climate Change, a legal comparative study between Goa, India, and Portugal, 2024-2026. Her publications in journals and edited volumes critically examine issues in global economic governance, including WTO dispute settlement, investor-state dispute reform, environmental law, and corporate social responsibility. Professor Rane has presented her research at leading international forums, including the University of Lisbon, National University of Singapore, and the International Law Association Biennial Conference. She is a recipient of the Young Scholars Award, and her work reflects a sustained engagement with contemporary debates on human rights and development. So please join me in welcoming our panelists. So we will begin on my right with Professor Rane. She is presenting her work entitled The Notification State, Executive Aggrandizement and Erosion of Human Rights in India's Coastal Governance. Professor Rane, I leave it to you.
Thank you, Professor, for the introduction. A very good morning to everyone. Thank you to the Gonzaga University School of Law, the Center for Civil and Human Rights, the Global Legal Education Program, and Gonzaga in Florence for the invitation. And I also thank Asian Society of Human Rights branch of the Asian Society of International Law for publicizing the call for papers which led me to this conference. It is a privilege to present this paper at the conference, which is focused on executive aggrandizement, the decline of rule of law, democracy, and human rights. Something which I see from the sessions, from the speakers, is quite pertinent. So it's an excellent topic that we are deliberating. My paper is titled, as Professor said, The Notification State, Executive Aggrandizement, and the Erosion of Human Rights in India's Coastal Governance. As you can see, I began the presentation after a lot of research on what art, because we are in Florence, what art would depict the concept of executive aggrandizement, and what called out to me was this painting of Napoleon's coronation, which is not in Florence, in Paris, painted by Jacques Louis David. Now, I use my imagination and I use it deliberately. What I see here is a moment which captures power which is concentrated in one, performed through legality, ritual, and sly institutional reform. Napoleon here does not abolish the ceremony, he occupies it. He stands at the center of legal and symbolic order and reorients it around executive authority. We can see the Pope present here, people who are not present here in the painting. All of it to show that yes, he has power and it is legitimate. And initially, from what I read, the painting was about him crowning himself. but here to depict for the public, it is him crowning his wife Josephine. This is a visual metaphor for this paper. Executive aggrandizement today often does not look like open illegality. It can operate through formal procedures, lawful instruments, technical classifications, and ordinary governance. In this paper, the instrument is environmental notifications that I look at. My argument is that the India's coastal regulation, with the case study of Goa, India, a small state of India, shows how executive power can expand through lawful delegated legislation and how human rights can be weakened not by abolishing them, but by making them contingent to executive maps, classifications, exemptions, and permissions of the executive. So, a brief literature review of executive aggrandizement. What currently the literature focuses on is the concept of democratic backsliding and executive aggrandizement as a part of it. It is the gradual and legal decline which leads to democratic backsliding. Scholars who have conceptualized this term and who have written about it, such as Nancy Bremo, Tarunab Khaitan, and others, have shown that executive power expands by weakening the vertical, the horizontal, and the discursive constraints while preserving the appearance of legality. Most of this literature studies familiar mechanisms, and something that we had seen in panel 1 as well, when constitutional amendments are brought in, emergency powers are brought in, the court, the judiciary is rigged, party state infusion takes place, electoral manipulation is something which is mentioned in the literature as well. However, my intervention is to ask whether we are missing a quieter, a more subtle way of executive aggrandizement. That is via delegated legislation, specifically in environmental law. In environmental governance, power often moves through these instruments that appear technical and administrative: notification, maps, exemptions, and clearances. These instruments do not look dramatic. That is something which is a part of the administrative process. But they determine whether fisher communities are protected, whether ecological safeguards apply, and whether public participation on paper and in reality does actually matter. So the contribution of this paper is to extend executive aggrandizement from capture of formal institutions to governance of rights through mutable technical instruments, technical legal instruments. So my central claim to this paper is I use the coastal regulation zones. It is not about illegality, which we have established by now. It is that power accumulates through technical legality. The CRZ regime, that is the coastal regulation zone regime that we'll be seeing further, shows how delegated legislation can become primary architecture of coastal governance. Notifications define protected coastal spaces, executive agencies classify, approve, exempt, grant clearances, and communities must claim their rights inside this framework as and when they can. That is why I use the phrase procedural preemption of rights. Even before you're granted it, they have this, the executive tries to regulate what your rights are. And by that I mean that rights are not directly abolished. Instead, the legal pathways through which people exercise are gradually redesigned. Coming to the research question and the methodology, it's a simple research question. Does executive strategic use of delegated legislation through CRZ notification create a notification state that aggrandizes executive power, destabilizes legal predictability, and affects human rights of coastal communities? And the method that I have used is threefold. Firstly, a forensic comparison of the coastal regulation zone notification of the three 1991, 2011, and 2019 of India, the institutional analysis of the horizontal and vertical checks, and the judicial rulings. And this is done with respect to the case study of Goa. Now, a legal hierarchy. Where does notification sit? As we all know, the laws, the constitution is the supreme law. The acts and statutes are primary legislations which have to conform to the constitution. Then comes ordinances, which are temporary legislation which have to be further notified. Rules, regulations, notifications, and bylaws are delegated or subordinate legislations. Orders, circulars, and guidelines are administrative directions whose force depends on the context. This hierarchy I have taken from the authorities such as MP Jain, Massey, Takwani, and the case law which is in regard to the Delhi Laws Act of the case of 1951. The CRZ notifications are legally binding. Delegated legislation under the Environmental Protection Act of 1986. The problem is not that they are informal or they are illegal. The problem is that they are subordinate instruments doing the primary work of regulating coastal areas. The Indian administrative law accepts delegated legislation as necessary. The Constitution as well mentions it. There are case laws such as I mentioned, the 1951 case and a later case wherein they have said that yes, delegated legislation is important, specifically when it comes to certain acts which are necessary and needs to be done quickly. However, the cases also mention that the delegated legislation must be within the framework of what the Parent Act authorizes. And here the Parent Act, mind you, is the Environmental Protection Act of 1986. Now, with that, let's go to the next slide, wherein I speak a bit more about the delegated legislation. And yes, I accept, and we all as constitutional law students, we realize that delegated legislations are important. Specifically in environmental law, which requires flexibility. Notifications can bring statutory provisions into force, regulate areas, technical standards, impose and grant clearances quickly, as well as exemptions quickly. The question is not whether delegation is valid. The question is whether subordinate instruments are now doing primary right effective lawmaking. Unlike statutes, notifications do not involve full parliamentary debate, clause by clause legislative scrutiny, voting on every major policy shift, sustained public deliberation, or the same political visibility as acts have. The CRZ notification of 1991, 2011 and 2019 are just one example. It's not that it is just the CRZ notification. Most of the environmental governance in India, be it the environment, your environment impact assessment, governed by notification. Your island protection zones, governed by notifications. Eco-sensitive zones, governed by notifications. Sound pollution, governed by notification. Wetlands, waste management, all governed by delegated legislation. So here I prove that delegated legislations are used as the primary instrument to govern environmental governance in India. With that, here I try to develop an operational test to identify whether the governance does come under the ambit of executive aggrandizement. I think I've been too ambitious with this, but I try to base my test on the theoretical foundations or the papers which have come before me. That is the first work, Barimo, 2016, Khaitan of 2017, and Lebens 2023, where they have explained and set out certain tests and have operationalized them. So based on that, I have a 5-test rule here. Firstly, reallocation of lawmaking power from legislative to executive. There is a weakening of horizontal checks, vertical as well as horizontal. There is narrow public accountability from the public. There is expansion of executive discretion to classify, exempt, prove and revise the notifications. And lastly, all of this leads to destabilized rights, and rights become procedurally insecure. So this is the test that I have, and let me just start by showing you some pictures of Goa. I just added them yesterday because I realized we need to know what a beautiful place that Goa is, and I'm fortunate to be from there. It's a very small state. It's a federal state in India. It is a 105-kilometer coastline. That's it. These are some pictures. This is not how it looks now. It's a 2010 picture, but it used to be beautiful. This is now. You can see what has happened to the coastline since 2010. And yeah, this is this is the state of Goa, which I have taken as a case study. Now, why taking you through where Goa is located? It's there, right? A small part. So just like Italy, India is a peninsula as well. We have a long coastline of around 7,000 kilometers. The CRZ lineage, just a brief story about it, how the coastal regulation zones came in India. In 1981, it was the Prime Minister Indira Gandhi's letter to coastal chief ministers who spoke about, who said that there is a need to protect the coastline. After that, we have the Environmental Protection Act. Then, why Goa again? There was a professor, Professor Sergio Carvalho. So he used to teach in Goa, and he was the first one, the first coastal regulation case law which came up was he was the one who initiated it against a resort which was coming up in a very beautiful place, and it was the Ramadan Beach Resorts by Wyndham. I believe it's a US-based chain of resorts, and it's called Carvalho Beach Resorts now. Not because of him, but it's quite satirical that he filed the case. The court said that no, you can't construct within 200 meters of no development zone. So they had to take their construction few meters back towards the landslide, towards landwards. But today this Ramadan beach resort is called Carvalho Beach Resort. Then soon after that, this case led to the Supreme Court directed that yes, there needs to be regulations. So we had the 1991 regulation. There were major amendments in 2003, followed by a need to change the laws. So there was the MS Swaminath Committee report in 2009. Then in 2011, we had a new law altogether, new notification. Again, it was revised by another committee, that is the Shailesh Naik Committee report. And in 2019, that is currently, we have a law which is in place. Now, why Goa? Because it is quite a small area, so I can do a complete research on it. Secondly, all forms, be it ports or construction or tourism, everything takes place in Goa. There is a lot of technocratic dominance that I have been able to witness, because this is also my PhD topic and also a topic of my project which I am doing. And human rights are at stake which are accessible. So this is the reasoning, this is the map. The tiny state of Goa accounts for 50% of India's CRZ violations, just to prove my point. Another point here, only 24% of CRZ breach plains lead to demolitions in the last 5 years. We'll see them later. Again, just an image. It's a bit too technical and we are short on time for that. This is the 2011 map, a conceptual diagram, and the 2019 one. What the changes are, again, in the forensic analysis, I'll explain to you how the law has changed, what rights the executive has retained for itself and aggrandized. Now the forensic metrics of 1991. I have an Excel sheet which runs into sheets with the forensic analysis. So I've tried to, for the purpose of this presentation, just put a few words which I'll be explaining as fast as I can. I have divided the notification into certain 11, I believe, components, and how they have changed from 1991 to 2019. The legal form. It comes into effect as a notification under the Environmental Protection Act of 1986 under section 2, subsection 1 and 2 subsection 2(5). Again, just the legal form, it continues, nothing changes over there. Regulatory structure, what the 1991 regulation governs, or how it governs, is by demarcating spatial restraints or mentioning the geographical limits. But 2011 and 19, we see that there is a lot of technocracy, or rather the involvement of land management, as Professor said earlier, the oceanographic experts, or your executive, which determines how the coastal zone management plans will be drawn up and where permissions would be granted. The coastal space remains same from the high tide line to 500 meters landwards is the coastal regulated zone. However, what has changed is the tidal bodies or rivers when it meets the sea. So what about those? Because those are very beautiful places in Goa where you can build and you get a sea view as well as a river view. So governing them and changing those, allowing instead of 100 meters no development zone, 50 meters of no development zone, which means you can construct more towards the seawards. So that is something which has changed when we speak about the coastal space in 2011 and 2019. Now the CRZ, the zones are 4 in number, 1, 2, 3, 4. The first one was simple as that, 1, 2, 3, 4. This in 1991. Sensitive areas, developed urban coastal areas. The third one is the rural areas with 200 meters no development zone. And then you have your islands. Now in 2011, there was a change. As the notifications progress, you will see that they become more technical and more well written. From my personal experience, I could read it better, I could understand it better. But what I also noticed is that within that language, there are more exemptions which are granted. They have categorized CRZ 1 into 1A and 1B. Now 1A is your ecologically protected zone, what was there in 1991. But in B, you see the tidal areas that I spoke about, the beautiful hills and where you get the sea view and the ocean view at the same time. Now that was in 2011. In 2019, there are further exceptions which are added to 2019. CRZ 2 are developed urban areas which continue to remain safe. However, CRZ 3, which are rural coastal areas, they are again divided into two, A and B. Once again, allowing development in CRZ 3B. So what we see is there is further definition or further classifications of the zone in order to allow more development. Then we have your coastal zone management plans, which are good. They mention what the zone is, where it is. It seems quite right. The more the specific you are, the more you can protect your rights. Right? But who demarcates this coastal zone management plans? The executive. Who approves them? Who changes them? The executive. So that's the problem we see. Now the process of consultation, public consultation when the maps are made, when the notification comes into picture. So let's just focus on the maps, when the maps are made. 1991 there was no much public consultation. 2011 there was an 18-month consultation period which was excellent. But in 2019 we see only 60 days of public consultation for over 3,000 opinions or challenges that it had got, and none of them were incorporated in the 2019 notification which came up. With regard to environmental clearance, there has been sub-delegation of the rights from your coastal authorities, your environmental ministry, to now the local town and planning authorities. So it has been the right or who decides whether a project will come up, whether the exemption will be would be given, are the local bodies, the executive themselves. When it comes to tourism, again 2019, the notification seems more like a land and tourism notification rather than ecological, something which protects the ecology and balances. It says that it is sustainably to have sustainable development in tourism, ecotourism, but it's mainly about ecotourism rather than ecology. When we speak about rights, consistently the language has been right-based. The fishermen, the rights of the fishermen, the right of the tribal community living around have been protected, but the application of it shows something else. So what do I analyze from the matrix? It proves that the rights repeatedly are governed by the executive. There is a shift from prohibition to procedural permissions. The jurisdiction expands, but the permissions, the right to give permissions are held with the executive. Rights have now become map dependent. Participation becomes preempted. You already have what the zone will be. You just come and give your opinion, public consultation. Ecology becomes managed risk now. So the final synthesis of this, the first part of my analysis is the 1991, the executive defined the coast, protection is distance based, the law makes the power. In 2011, the executive maps the coast. Rights are routed through coastal management plans, and it is more cartographic. That they specifically mention the survey numbers and what uh, what property lies at the high tide line and low tide line. But in 2019, the executive relaxes the coast a lot more. Protection becomes permission dependent, and this is exemption power. So CRZ lineage does not abolish rights, it relocates them in executive controlled maps, classification, exemptions and clearances, and that is what I call the notification state. The second test that I have is the institutional check, the horizontal and the vertical one. Yes, the CRZ went through a horizontal check in the parliament. There was a 15-member Rajya Sabha committee on subordinate legislation which questioned the coastal buffers, the weakening of CRZ protection. But what happened? Nothing. It's an executive delegated legislation. It was passed. It was implemented. Then you have your Comptroller and Auditor General of India. In 2022, it had a report, report 4, wherein it examined the functioning of the coastal bodies, your coastal zone and the National Coastal Zone Management Authority. Again, it showed that these bodies do not function well. There are people not appointed in these authorities. When looking at the parliamentary debates, yes, the question of CRZ has been debated through Lok Sabha, that is the House of the Commons, quite a number of times. And every time the minister has defended the law, that yes, it is a law under Article 13 and it has a force of law. So although the notification state does not abolish checks, we can see that they have bypassed the vertical check by making it a delegated legislation. Another point which I would like to make is that in the US you have the Coastal Zone Management Act of 1972. In the case study that I am doing in my project of Portugal, you have your Programa de Orial Costaria, which is by a decree of 1993 and 2012. Again, all of them are acts, but in India we see that they are not acts, they are just your delegated legislation under the umbrella of Environmental Protection Act of 1986. Vertical checks, yes, there are public consultations, news and media to a certain extent, pre-formulation consultation, but again, namesake, because you have your zones which are already demarcated. Academics and civil society, yes, they voice out their opinions, but again, they remain invisible, and it's just on paper, on newspaper, on journals, in journals, or on Facebook and Instagram. Last part, the judicial checks, yes, the judiciary has been quite active when you read the judgments and you see the judgments. But increasingly, as I have noticed today, nowadays, the judgments are more in favor of development rather than ecological protection. And what strikes me is none of these cases have ever challenged why in India is the environmental governance done through delegated legislations and not acts specifically to govern such large areas such as the coastal area, 700 kilometers of the coastline. Here we have seen judiciary repeatedly recognizes environmental and community rights, but the realization finally depends on the executive implementation. The same executive that frames it, classifies, relaxes and enforces this CRZ regulation. It's not just your delegated legislation, even office memorandums or local permissions are used as a defense in order to construct something which again judiciary has checked time and again, but the executive continues to do it. So what is the point of the judicial check? Another point that I use here is, okay, to protect the olive ridley turtle, the area, the nesting area, the judiciary came up with a judgment, but despite that we see tourism taking place because your delegated legislation allows it. So that is one point. Lastly, I think it's visible. So lastly, I want to show the transition of cases where in the first case, Professor Sergio Carvalho versus the GCZMA case, there was regulation of the coastal zones, but construction was allowed. Goa Foundation versus Coastal Zone Management Authority, there was a wall built up. Thank you. There was a wall built up. Again, the court allowed it. Now we have the Ashish Kothari versus Ministry of Environment, Forest and Climate Change, something which is going on currently. This was the NGT National Green Tribunal judgment, wherein they said that, wherein they allowed development of this island. It's not related to Goa, but the Andaman and Nicobar. There is a Great Nicobar project coming, which again, how does it come? Was it debated in the parliament? No, it gets the right. The executive gets the right to build this, to construct this by your island notifications, your CRZ notification. So it was just a notification which allowed the development of this very fragile island into which is being constructed right now. Again, it is still under, now they have appealed to the Calcutta High Court in another case that is up for hearing on 23rd of June. Yes, there are human implications. I'm sure we have realized that there is threat to livelihood of the traditional fisher folk, violation of rights to healthy environment, violation of participatory governance, displacement of the social impact. So finally, yes, this delegated legislation and executive aggrandizement does affect our human rights. So just some clippings to show you that yes, it's not just me saying it. These are news reports of which show that there is human rights implication of this. The word executive aggrandizement is not used. They are just human rights violations. So finally, I prove my test. So the test which I laid down initially, I can see, as per my opinion, it's a yes for all. Relocated lawmaking power, weakens the horizontal checks, narrows the public accountability, expands the executive discretion, and finally destabilizes human rights. So the test is satisfied, the test that I laid, and that executive aggrandizement takes place through legality and not through illegality. What I also realized is the next step for me is to have a public consultation, or rather an interview with the public, in order to ascertain that yes, human rights are violated, and it is not just the news. So just to strengthen my claim that human rights violation takes place, I have seen the news media, the news reports, my test, and finally it is based on the interviews with people. We can finally concretize and say that yes, human rights violation takes place because CRZ is a notification and not an act. And yeah, I think that's it.
Quick moment for presentation switch.
Again, hello everyone, my name is Nguen and I'm from Vietnam, and I have took a 15-hour flight here to Florence to present a case study for my country here. And before I begin, I would like to express my gratitude for Professor Brenda and also the Gonzaga University for giving me this opportunity for the first time in Europe, not just Italy, the first time flying in Europe, to bringing the case study from Vietnam, a country from the Southeast Asia. So my presentation will focus on the concept of climate justice. I would like to, bring you a brief background on this concept later, but this won't be about the climate policy that are creating or identifying the injustice. in many countries, and the case study here in Vietnam, and especially with our ethnic minorities. So my presentation will be categorized into four parts. The first thing that will take you to a theoretical framework that I would like to raise in my presentation, and the second thing for you to have a background knowledge about our country, our ethnic minorities. And a third part of my presentation is we come back to the concept of climate justice and how climate policies are identifying the climate injustice. And the last thing that I would like to raise here is that we could use a human rights-based approach in order to achieve the climate justice in the context of climate change. And first thing first, about the theoretical framework, because my presentation will focus on the land rights of the ethnic minorities. So I would like to introduce to you how land rights are defined or provided under international human rights law. And here's the thing that we have first the ICCPR, the International Covenant on the Political and the Civil Rights. And actually the land rights were are not mentioned directly under this covenant or other covenants of the international human rights law. But in this case, I would quote the Article 27 is saying that in the country or in those states in which ethnic or religious or linguistic minority exists, that the state party must make sure for them to enjoy their own culture. And under the general comments of the Human Rights Committee, they interpret that the culture here can also manifest the right to the land of the ethnic minorities. And beside the ICCPR, we also see that the ICSCR as well, the International Covenant on the Social, Cultural, and Economic Rights. And in the Article 11 of this covenant, the state party are required to to recognize the right of housing of the people. So I see that in those two covenants, land right, even though they were not mentioned directly, but they were mentioned indirectly through they are defined that land will have a relationship with the residential areas of the people and also the making use of land resources for the livelihood. But so what is so special about the ethnic minorities or the minority groups and the land? And in this presentation, I would like to argue that it's for them. It's not just where the place that they live or the place that they using the resources for their livelihood, but it's connect to them even broader. The first thing is that they are offer the communal structure. For example, in Vietnam, we have a lot of ethnic minorities. I would like to bring you the figure number later in the presentation, but. When it comes to the land of the ethnic minorities, when they choose a certain land to live in, they choosing their community to reside there. So not just the house or the land for the cultivation, but also maybe some community ritual or even the cemetery. Everything was in that land. So it's not just a normal land, but it's just their sacred land in that area. And the second thing about the ethnic minorities is that they also connect to land, maybe culturally and spiritually. They conducted a lot of ritual, the prayings, and a lot of practices in that land. So it is I would like to argue that it is so much important to them when it comes to the connection to the lands and the forests regarding the ethnic minorities. So that is the first thing that I would like to raise in the theoretical framework about the land rights. And the second thing here is about the concept of climate justice. This is not a new concept that is actually originated from the environmental justice that was born in the North Carolina in the US in the 1970s. In particular, the Warren County, when that area was chosen to build the landfill for the area. So the environmental justice concept was born in that period. And when the climate change comes, that concept was put in a new context. It's a climate change, so it rebirth as the climate justice. And if you may, heard about the advisory opinion of the International Court of Justice last year regarding the state responsibility regarding the climate change impacts, you will see that in that advisory opinion, the ICJ has raised the, aspect of justice is that when it comes to climate change impacts, there are some groups of states maybe disproportionately affected by the climate change, like a developing country in like our country Vietnam, and also the small island country or the least developed countries. And another aspect of justice that was raised in that advisory opinion is about the injustice between the future and the present generations. But in my presentation, I would like to bring us go back to the traditional concepts of the environmental justice. It's between the minority and the majority communities within a state. And the climate justice are, they are demonstrated in the three aspects. The distributive justice. It means that when it comes to climate change impacts, it requires the, the equal distribution of both environmental costs and the benefits. So when it comes to climate change impacts, it requires to have an equal distribution of both of the benefits or the costs when it comes to climate change. And another perspective of the climate justice is the procedural justice. It requires us to to improve or to enhance the participation of anyone that were impacted by the climate change in the procedure or the policy making procedures. And the last aspect of the climate justice is the recognitive justice. It requires the recognition of the whole society about this injustice, so we can involve all kinds of stakeholders in order to achieve the climate justice. So it is the second concept that I'd like to raise here. And the last concept before we go into the case study of Vietnam is the human rights-based approach. It also is not new. It was raised by the United Nations in their guidelines for the Sustainable Development Cooperation Framework. And the human rights-based approach here is, it has a guidance for states to incorporate the standards and the principle from the international human rights law into their policy and the laws in order to make sure that no human rights are violated during the policy making process. So this won't be the method that I would like to recommend, that it should be incorporated when any state, including Vietnam, designing their climate policies. Okay, so that is first part from the theoretical framework. Now we come to the case study in our country. So I know that not many of you have heard about, or visiting other country or have heard about our ethnic minorities. But there are fact that we have 54 ethnic groups in our country, and 53 of them are minorities. And we can see in the chart here that the ethnic minority accounts for over 14% of the total population. But besides, you can also see the map of our country. And in the green showing that on any provinces, we have the green showing that it is a distribution of the ethnic minority population. So you can see in this map that ethnic minority in Vietnam living across the country. And they normally divided into three regions. We have the northern mountainous, and we have the central highland in the middle, and we have the coastal provinces. So each of the group living in these three regions, they having different kind of vulnerabilities when it comes to climate change impacts. So that's the thing in Vietnam. We have to deal with the the differences or the distinctiveness of the 53 ethnic minority. And also in the country, we also seeing that we have a very, very long coastal. And when it comes to climate change, we have to suffer to different kind of impacts of climate change, from the sea level rising and the rising of temperature and the extreme weather events. A lot of impacts of climate change hitting our country. So we have to deal with the climate change at the same time, and we also have to deal with the the equality between the minority and the majority. And another thing that I would like to introduce to you here about our country is that we have acknowledged that minority or ethnic minority is in a country are very vulnerable. And for a long time, we have took a lot of, policy in order to give them some kind of priorities. And actually, we are from the civil law country, so we have a lot of legal documents. And when it comes to the legal document regarding the ethnic minorities in Vietnam, we have over 300 legal documents just about the ethnic minority issues. But when it comes to the land rights, the topic of my presentation, I would like to introduce two, important legal document when it comes to the land right of ethnic minority is our land law in 2024 and the forestry law in 2017. And both of the legal documents also raising the issue is that ethnic minority living mostly on the mountainous areas and living in some area that can be easily affected by climate change. So the state or the government, they bear the responsibility to give them the priorities. For example, in the Land Law 2024, the ethnic minority living in a fragile areas, have a priorities when it comes to land tax, for example, or when their land are affected, they will be allowed to relocate to another land in order to make sure that you can, living in the safe place. And in the forestry land, we are, trying to harmonize one side with the forest conservation, and also the fact that the ethnic minority are also living in the forest that were protected. So we also raising the principle when it comes to the forest conservation. We will try to harmonize between the forest protection and the rights of the ethnic minority. But that was all in principle. When the climate change hit, all those legal documents, even old, even new legal documents, are affected by the climate change policy. So how has it affected our country here? So we have a lot of climate policies, and in order to analyze the relationship between the climate policy and the land rights, I would like to raise here three categories of climate policy that Vietnam and I know that many countries are conducting in order to adapt or to confront with the climate change impacts. And this policy that I took them from the National Adaptation Plan that Vietnam submitted to the UNFCCC, and also the NDC, the nationally determined contribution that submitted to the Paris Agreement. So we have three kinds of climate policies. And in the next part of my presentation, I would like to demonstrate that these climate policy may be very effective in achieving the climate change goals, like the reduction of the greenhouse gases, for example. But in return, they are affecting the minorities. And the first thing here is the relocation policies. So Vietnam have been since 2006. We have acknowledged that there might be some area been, really being badly affected by the extreme weather. So we have a long-term plan since 2006 in order to relocate people that living in the fragile areas. But when the climate change comes, it will come to the long-term programs, it will take a lot of time for them to relocate. But when it comes to the, extreme weather, like we have the Yagi typhoon in 2020, many of people losing their home, and the government, they are very quick to relocate them in another place. When it comes quick here like that, you will see that it's a very good thing for people in a very short time to find new place to live. But as I mentioned in the first part of my presentation, is that when it comes to ethnic minorities, land is not just a place to live. When they are forced to living there, traditional land, they will find it very hard to adapt with the new land. So that is the thing about the relocation policies. It may good when they have a safer place to live, but maybe it's not really good for them when they have to leave their traditional land behind to living in a new place. And this is the first kind of policy. And we also had a second kind of policy in the renewable energy development. Many countries in our country, we started to develop the solar system power on the wind power, and it required the construction of a lot of power plants. And the power plants is normally in our country, they were planted or they are constructed in the area of the living area of the ethnic minority groups. So the first thing that they will have to relocate in another place, and the relocation that I will mention earlier. But when it comes to the renewable energy development, it also have another effect, is that the the energy development is not just you constructed the power plant and it's done, but it requires many other responsibility from the investor. Like you have the environment protection, in the surrounding area of that projects, for example. So the fact that because we have a lot of time to for my presentation, so I'm not mentioning a lot of data and figures, but there is a lot of examples that we have in Guangxi province, for example, that people are relocating, but we still have people still living surrounding that area, so they have to suffer from landslide and the waste from the power plant. So they find it's really hard to keep living in that area, but they are not within the project of the relocation. So they have to stay there and suffer from the impacts of the energy development projects. And this is another thing. And the last thing that I would like to mention in here is about the conflict between the forest protection and the land rights of the ethnic minorities. So in the forestry land, in Vietnam forestry land, we divided forests into 3 categories. We have the production forest that people can allow to have the production in that area, but we will also have the protection forest and the special use forest. And these two and the 2 latest categories forest, they are reserved for the protection, the conservation, or the tourism purposes only. So people technically cannot live or cultivation in that area. But as I mentioned that many ethnic minorities in Vietnam, they have long living in that forest. So with with the affected them belly when they have to leave in order to compromise with the forest conservation. So actually in Vietnam here I mentioned one kind of policy that we are experimenting is the payment for forest environmental services. Is that we are trying to allowing people to stay in their place and paying them to participating in the forest protection programs. In other words, we're paying the ethnic minority to helping in the forest protection. But there is a problem with that. The first thing is that the payment is not long term, it is very short term. And the second thing is that the payments are they are not some permanent income for them, but they have the rotation from village to village. For example, if this year the village A have the payment from these, from these projects, so the next year they have to switch this income to another village because the government do not have sufficient budget to, provide this payment for everyone living in that area. So they have the rotation. And another thing here is that when people they just depending on receiving the payment from the government, they don't have any kind of other income. This won't be very affecting them when that income starts. And according to a survey that 1/5 of the ethnic minority are receiving the payment from the forest environmental services in one of the province, or one of our province in the Cát National Park. And that's 1/5 of them having this kind of payment is their only income. They do not have any kind of income because they have to participate in the forest protection program. They are not allowed to cultivating or doing other cultural activities in that area. So they do not have any kind of income. So it will be very dangerous when that income starts. So there are in overall, I have introduced you that there are 3 kinds of climate policies that may be very good at achieving the climate change, the climate change outcomes or climate change adaptation outcomes, but it can be adversely affecting ethnic minorities. And in the last part of my presentation, I would like to raise here that is not just come from the climate policy itself, but sometimes it's come from the ethnic minorities. I'm not sure if you have some ethnic minority or indigenous minority in your country, but they reflect that they sometimes the right of education, for example, are not sufficiently fulfilled because like they living in the remote area, so maybe the access to the information or the access to education is not high. So it also comes from them when they have limited capacity when it comes to climate change policy or the right or the recognition of their right. So the thing that I would like to raise here is that the human rights approach can be an effective tool in order to achieve the climate justice for the minorities for the reason. The first thing is that it already have a normative framework. We have a system of international covenant of human rights that like believing the binding responsibility for states. And another thing, when it comes from the people, like we have a view from the very early stage of the conference, when it comes to from the people, it may be more like comprehensive and inclusive policies. So how human rights-based approach can be like applied in order to achieve climate justice. So if you remember that I introduced to you that climate justice are like demonstrated in three aspects: the distributive, the procedural, and the recognitive justice. And now I will explain how human rights-based approach can, or human rights tools can use or can be applied to achieve each of the perspective of the human rights justice. The first thing, the equal distribution of the costs and the benefits when it comes to environmental impacts of climate change policy. The first thing is the reinforcement of the principle of non-discrimination when it comes to human rights. So we have learned that when it comes to the fulfillment of rights, we shall not, like discriminate on the basis of the ethnic or the religion or the nationality. So the reinforcement of the principle of non-discrimination when it comes to the design of the policy, the climate policy are very important. And the second thing here is that the ICSCR, the International Covenant of Social, Economic, and Cultural Rights, have a very, like interesting tool. That covenant, they recognize that when it comes to human rights, we cannot make the standard or the standard of right are the same between the developing and developed country. Or they recognize the fact there may be the differences of development between states, and it can result to the fact that the level of human rights protection or promotion can be different from state to state. But in that covenant, they say that even when there are differences, the state, even with the least level of development, should should provide the minimum core or minimum standard of rights in order for them to avoid the the violation. So I argue that if the climate policy are designed in order to giving the minority at least a minimum standard of right, it can help them to protect their right even with the minimum standards. And another tool of the human rights-based approach is the 4A scheme. It requires the fulfillment of rights in order to provide the accessibility, adaptability, acceptability, and accessibility. So this 4A is helping like government in Vietnam in order when they design the climate policy, they will make sure that the rights are fulfilled comprehensively. For example, when it comes to land, it's not just access to land, but it must be acceptable. For example, like the quality of land can be suitable for the cultivation or the adaptation. When there is a change of the quality of land, for example, the government should be like adapted with the change of climate change. And another thing is about achieving the procedural justice to the human rights-based approach. The first thing that I would like to raise here is the truth of the threefold obligations. It's saying that the obligation of state are not just something that we just respect the right or to avoid to harming the right, but the threefold obligations under the international human rights law require that the state must actively in order to create the mechanism. For example, here is the procedural justice. It requires to enhancement of the participation of the ethnic minority in the policy making. So it's not just they are refraining from like restricting their participation, but they must create a mechanism for them in order to actively raising their voice into the making process. And another thing is that when all rights are connecting, we're not just saying that when ethnic minorities are like fulfill the right to participation, the government should also care about other rights as well. Maybe when you can read, you can know that how can we participate in climate change. Or many ethnic minorities, they have no idea about the concept of climate change, for example. So I argue that when it comes to the right, it should be the fulfillment of the comprehensive of the rights. We have to fulfill the right to participation in the same time with other rights, like the right to education or the right to information access. And the last part of my presentation here is the achievement of the recognitive justice, of how the society should involve in the recognition of the rights for ethnic minorities that come from directly from them is about the traditional knowledge. We, like in my country, in the 53 ethnic minority group, they are, because they are traditional, living in one area for a long time, they have not a lot of knowledge in order to adapt with the weather, like the weather events, or adapt with many impacts of the climate change that maybe we are not, know about that. But they are the people living in that area maybe for 100 years. They know a lot about their place of living. So I think that besides the policy just come from the state, it should also come from the ethnic minorities, because they can contribute through their traditional knowledge in order to design the climate policies. So this is the end of my presentation. That I thank you for listening. That I would love to receive some comments and questions from you. Thank you.
Okay, those were incredible presentations, and we're all extremely fortunate to have you both presenting your topics before us today. So we have roughly 10 to 12 minutes or so to engage in Q&A, and so I'd love if anyone could show by a raise of hand a question for our eminent scholars here. A lot of topics on my mind, but I thought maybe we could sort of kick it off to some of the audience. I'm also thinking of my comparative con law students when we discuss the comparative method. Right, so hopefully you're thinking of some of these ideas as we discuss very important questions of climate justice and coastal management. So by show of hands, perhaps okay, if we have, I guess this is the only one, okay. Maybe you can state your name and ask your question.
Hello, my name is Tavion. In conducting the GOA case study, what level of authority would you argue that the administrative state should have in a system of seemingly legislative acquiescence to ensure protection of human rights? And then on top of that, is it still an issue of executive aggrandizement in light of such acquiescence?
Open question for.
Thank you for the question. So the question is, what level of authority, in my opinion, should the executive have when it comes to coastal regulations, the zoning? Okay, so how I see it is, when you speak about water management or air management, the pollution, in India they are formulated into acts which have been deliberated, which have been thought about. They have authorities which are built within this acts, which enforce the laws which are stipulated in the respective acts. But when it comes to your coastal regulation notification, it is the same template. However, the executive makes the law, implements the law, remedies it in case it goes to the judiciary. So the level that I believe is there should be a formulation of an act by the legislature which then should be implemented by the executive. I think that would be one way to have a check on what happens to the coastal zones. And your second question was, do you think that would help to eliminate executive aggrandizement?
Not quite. So I guess my second question was, you provided that it's been around for many decades, and there seems to be a level of legislative acquiescence in terms of actually passing their own act. Do you still think it is an issue of executive aggrandizement if there is that level of legislative acquiescence in that process?
No, that would eliminate it to an extent.
Okay, other questions? Other questions? Okay, I'll ask a question. Why not? I have the mic, so I feel like I'm kind of facilitating a after event right now. So it seems one of the major themes across both of your papers is sort of the relationship between technocracy or kind of over-technicalization, right? Whether it be land coastal management or policies in Vietnam with respect to minority groups, et cetera, et cetera. What is that relationship in sort of us being able to intuit executive aggrandizement through technocratic approaches, right? So in other words, what is the relationship between technocratic approaches towards pursuing perhaps, environmental-driven policies and the protection of human rights and democratic accountability, right? Because we're sort of moving the locus of rights protections from sort of, ICCPR ideas or constitutionally protected rights into sort of climate-based policy goals, right? So I'm sort of thinking of, what should we learn from this kind of shift, right? And how we think about pursuing climate change and also the protection of rights. Is it sort of becoming more technocratic in that way?
So, absolutely, I agree with you. While I have been doing my research, my PhD, as well as the project, understanding the CRZ, which is, I believe, becoming more and more technocratic when it comes to the management plans, or even the drafting of, the zoning of it. It has become technocratic, even when it comes to resolution of disputes or the judiciary. I believe even they have difficulty in understanding the law and then applying it. So they have the amicus curiae and then all of that. But again, on the flip side, having technocracy means that we are making the laws in a more scientific manner, but then understanding them for the public, the lawmakers and the jurists is becoming difficult. I think it's necessary to have technocracy, but again, not too much of technocracy. That's my understanding. Yeah, I think that's all I have to say.
Okay, thank you. So about the question about the relationship with some, aspect of technical, and I think that when it comes to climate change, like he says that the scientific data, for example, are very important. But if the government just focus on that, I do this because we have the evidence from the technical data, for example. But when the people, they, do not understand, like the ethnic minorities in my case, for example, they have no idea about that technical. So when the government implement that policy, maybe they are very effective in achieving, the outcome of the climate change adaptation. But when the people, do not understand about this, there may be some, for example, in my case, that when ethnic minority, they are relocated in another place, and the state and the government say that it's very good, you are moving in a safer place, so why don't you like that? But from the side of the ethnic minorities, they say that they are being forced into moving to the place away from their sacred lands. So I think that even when the climate change policy are designed based on the scientific or the technical data, they should make sure that everyone should acknowledge about that, even in the minimum standard. Yes.
So, question over.
So my question is a couple of questions actually. What do you think would be the best way to resolve these problems and have more of the government, in your example, care more about taking care of the environment, and on your example, in addition to caring about the environment, make sure that that they have more protections for the people. I think it's more cultural awareness. Is there a reason that they're not valuing as much because it's a bit more of a shift to focusing on science, or is it like less cultural focus, or what's the reasoning for this change, and how do you fix it?
Okay, thank you very much for the question. I think that when it comes to climate policies, it should not come from one perspective. I think that it should be the intersection between different like sectors, even from the technical issue or maybe some other thing that. But in my presentation, I would like to raise that in my country, when it comes to the rice base, is not very value in the country. So I would like to argue that even when you design the climate policy, that it comes from information from other sector, you should also take consideration of the human rights aspect. So here the human rights-based approach, I'm not argue that is the only approach or the only tool in order to achieve climate change, but it should be incorporated more in the policy making process. Yes, so it's not the shifting completely from one approach to another, but it's an incorporating from the current design of the climate policies.
I believe I would again connecting both the questions about technocracy and the approach to coastal management. To a certain extent, I do believe when it comes to the coast, we need to have technical expertise. We cannot depend solely on the rights of the fisher folk or the indigenous living along the coast, for that matter. Because we look at sustainable development.